Okay, so let's get right into it. We usually think of law as something written down, in these massive, heavy books. But what if I told you that in one of the world's oldest legal systems, a rule that has never been written down can actually be more powerful than one that has? That's the wild idea we're digging into today, the amazing power of custom in Hindu law. Just look at this sentence. It's from a court ruling well over 150 years ago, and it completely flips the script on what we think law is. It's this powerful, kind of counterintuitive statement that laid down a core principle. If you can prove a long-standing tradition exists, it can actually beat out scripture or written legal texts. I mean, that one idea set the stage for decades of legal debate. And that brings us to the big question, right? It just seems to go against everything we're taught about how law is supposed to work. How on earth can something as, fluid as a tradition defeat something as solid as a written rule? Well, to find the answer, we've got to go back to the very beginning. To really get our heads around this, we first have to understand what custom even means in a legal sense. It's not just about, habits or what your family does for the holidays. It is something way, way more significant. In fact, custom is considered the very first, the most ancient, and the most original source of Hindu law. So what is it exactly? Well, a custom, or Āchāra, is basically a rule of conduct that's been followed for so long and so consistently that the community just starts treating it as if it's legally binding. You can think of it as law that is lived, not just written down. It gets its power from generation after generation, just accepting it as the way things are done. Now, here's what's really cool about custom. It works on all these different levels. It can be super specific, like applying only to one family's unique rules about who inherits what, or it could apply to a whole caste or community, or even everyone living in a particular town. And then sometimes, like with the Sethupathy marriage ritual, it becomes a general custom that almost everyone follows. But, and this is a big but, a family can't just make up a custom because it's convenient for them. No way. For an unwritten rule to actually get the force of law, it has to pass a whole series of really tough legal tests. And believe me, it is not an easy bar to clear. Think of this list as a legal obstacle course that a tradition has to get through. First up, it's got to pass the tests of time and consistency. It has to be ancient, so old that lawyers say it's from time immemorial, which basically means no one alive can remember when it started. Plus, it has to be continuous and really clear, not some vague thing people just started doing. Then, it has to pass some social tests. Is it seen as a binding rule, or is it just optional? Is it reasonable, or totally absurd? And finally, it has to play nice with the modern world. It can't go against a written law or what we call public policy. Only if it clears every single one of these hurdles can a court say, yep, that's a valid custom. So this all sounds great in theory, but what does it actually look like in a real courtroom? Because this isn't just some abstract idea. There are several huge landmark cases that have cemented the power of custom in real-world disputes, and they show this principle in action perfectly. The Collector of Madura case from 1868 is the big one. It's the bedrock. That's where the Privy Council first declared that a proven custom about adoption could actually override the written religious texts. Then you can fast forward all the way to 1985 in Balwinder Singh versus Gopal Kaur, where a court actually upheld a customary form of divorce, which shows these traditions can even survive modern lawmaking. Other cases figured out how you prove a custom, for example, by letting elders from the community testify, since they're the ones who carry the unwritten memory of these traditions. And this brings up a really crucial point. If you walk into a courtroom claiming a custom exists, the entire responsibility, the burden of proof, is on you to prove it. And that is a heavy, heavy lift. You can't just stand up and say, oh, it's our tradition. You have to bring clear, consistent, and lots of examples showing that this practice is treated as a binding rule. So we've established that custom is powerful, right? It's almost like this secret legal code that's embedded in society. But what happens when that code clashes with the modern world? Well, that's where the story takes a really interesting turn, because modern legislation has drawn some very clear lines in the sand. And right here, on this slide, you can see the single biggest shift. The original principle from way back in 1868 was that a proven custom could beat a written text. But modern laws, like the Hindu Marriage Act of 1955, added a critical new test. A custom is flat out invalid if it is opposed to public policy. And that's just a legal way of saying that no matter how ancient a practice is, it can't be enforced if it violates our modern sense of justice, fairness, and what's good for society as a whole. So you see, modern law is kind of doing two things at once. On one hand, it preserves and protects legitimate customs related to things like marriage and inheritance. But at the same time, it actively restricts and gets rid of customs that we now see as social evils or just harmful practices. It has also put the definition of a valid custom into the law books, which stops people from just inventing new traditions to try and get around the law. All right, so where does all of this leave us today? Well, custom is still a deeply, deeply important part of Hindu law. Sure, it's been shaped and even limited by modern laws, but its fundamental character as a source of law hasn't been erased at all. So, if you're going to remember anything from this, here are the key takeaways. First, custom is the original, the OG source of Hindu law. Second, for any custom to be legally recognized, it has to pass that incredibly tough 8-part test. Third, huge court cases have confirmed again and again that a proven custom really can override written texts. And finally, modern law has created this careful balance. It protects legitimate customs while making sure they don't violate public policy. And all of this leaves us with a final, really big question to chew on. This conversation between tradition and modernity is always happening. In a society that's constantly changing, how do we decide which of these unwritten rules are valuable traditions we should protect, and which ones are just outdated relics that the law needs to leave in the past? That's the challenge that our courts, and really all of us, continue to face.